Legal objections to the NCAA's proposed $2.8 billion athlete compensation settlement intensified this week, as attorneys representing objectors submitted a dozen filings challenging the agreement's final approval. The settlement, which would cover nearly 400,000 current and former athletes, aims to resolve 3 antitrust cases and launch a new system for direct athlete compensation beginning July 1st, based on a revenue-sharing model and subject to per-school caps. A primary point of contention is the inclusion of new roster limits that would replace traditional scholarship caps. Critics argue that thousands of walk-on athletes could lose their roster spots if the deal is approved, and recruits have reportedly already been impacted by preemptive decisions from schools. Objectors contend this violates due process, arguing that schools acting on a proposed, not finalized, settlement undermines the legal process and harms athletes, who were never given a fair chance to respond. U.S. District Judge Claudia Wilken, who presided over the April 7 hearing on the matter, could issue a final ruling without seeking further input. Though she previously suggested a possible phase-in of roster limits, the NCAA and Power 5 conferences rejected the idea, citing the logistical burden of changing course and asserting that the settlement remains legally fair, reasonable, and adequate. Opponents, however, pushed back hard. Attorney Laura Riathaford accused the principal parties of unilaterally treating the preliminary approval as final, thereby ignoring the rights of those affected. Meanwhile, Michael Hausfeld raised concerns over the settlement's 10-year scope, arguing that future athletes are being stripped of their rights before they can even voice opposition. He called the proposed notice and objection process for future classes inadequate under existing antitrust and due process law. Additional challenges came over the college football playoff's role in this settlement. Attorneys for Florida State's Thomas Castellanos argued that changes to the language involving the CFP were too little, too late, leaving athletes without enough information to make informed decisions on opting out. They asked the court to strike the revised language altogether, which could trigger further delays and complications for schools preparing for implementation. Gender equity also remains a flashpoint. Some objectors maintain the proposed damages structure could violate Title IX. While Judge Wilken acknowledged the concern, she has previously stated it lacks legal standing in these specific antitrust suits. Still, the final decision now rests with her, and the outcome could reshape the future of college athletics.